Steve, thank you so much, sir, for coming on the program this evening.
My pleasure, Tim, as always.
Great to be talking with you again. And, so many pieces of litigation out there in the wake of Heller and McDonald. It's hard to keep track of them all. One of the cases that you're heavily involved in is the Heller 2 case, challenging the District of Columbia's post-Heller gun laws, the laws that were put in place after the district's gun ban was struck down. Now, where are we in this case right now, Steve?
Well, we filed suit, just backtracking a little bit. The Supreme Court announced the decision. D.C. officials went out front and said, we're going to make life even worse on gun owners than it ever was, and they passed laws accordingly. We contested that. The U.S. District Court said, well, Heller said it's a fundamental right just twice, so we don't think it's a fundamental right. They didn't say it enough. So we're not going to have a high standard of review. And they basically, whatever the D.C. Council said in its committee report, the district court repeated that, and therefore D.C. wins. So we filed an appeal immediately. And where we are now is that we filed our initial appeal brief, D.C. filed a response, and we're getting ready to file a reply brief. Now, D.C.'s brief is really interesting. They can no longer deny that it's a fundamental right because McDonald said so. But here's the story. They argued in the court below that it's not a fundamental right, and therefore there's a low standard of review. They call it reasonableness, which means anything they want it to mean. Now that they continue to argue for this reasonableness standard of review, even though the premise for it, that it's not a fundamental right, it has gone by the wayside.
Well, yeah.
So anyway, we're in the process of briefing the standard of review. We say that it's a fundamental right, and therefore the ordinance has to be strictly scrutinized by the court. Or in the alternative, what we call in Heller a categorical approach could be applied, where the Second Amendment says you don't infringe the right to keep and bear arms, handguns are arms, and therefore you throw out the law. Either one of those standards of review would allow the Court of Appeals, that is, to throw out the registration scheme and the so-called. Those are the two substantive issues. Once we get past the standard review, we take it head on in terms of the following, that D.C. requires all guns to be registered. Can you imagine any other constitutional right that you've got to register with the government to do that? To possess guns in your home, they have to be registered. Would you have to register to have free speech or practice religion in your home? I don't think so. And then the guns they call assault weapons that we know are just ordinary semi-auto rifles by and large, like the AR-15.
Mm-hmm.
They make claims like, they're designed for military use. And there's no military force in the world that uses these. In fact, they say these guns are preferred by terrorists, military forces, and criminals. And when you look at the data, why would a terrorist or military force want to use a gun that only fires once per trigger pull?
Well, yeah.
I mean, service rifles throughout the world are full auto. So there's nothing to their case. They think that they could just say something in the committee report and that the law should be upheld.
Yeah, and Steve, it's just when you lay it out like that, comparing what they're doing to the Second Amendment rights of district residents compared to the First Amendment rights that these folks enjoy. We were talking with Dave Kopel last night about some proposed gun laws in Puerto Rico, where they're trying to say that you can only be limited to shooting 500 rounds of ammunition per year at your local range or gun club. That
right.
The gun club has to keep track of what firearm you used, the number of rounds that you shot. I mean, I can't imagine a politician out there seriously proposing, you're only allowed to write 500 words per year in terms of political speech. You're only allowed to buy one political book per month. And there are certain types of political books that are just off limits, the kind that are really popular. Those are allowed to be banned.
Right.
And we're not violating anybody's freedom of speech, anybody's freedom of expression.
Well, I'd like them to send bureaucrats out to gun ranges and make them sit there in the heat and count every round that's fired. I did read about Dave's analysis of that, and it's pretty. It's the same in line with what D.C. is trying to do, that to make it as hard as possible to exercise the constitutional right. And in D.C., by the way, we're joined by the historians, quote unquote, like Tom Cornell doing an amicus brief, and also the Brady Group doing an amicus brief. The historians basically do more distortion than history. They say things like there were registration laws since the early republic.
Mm-hmm.
And what do we end up with? Well, there were some gun laws like they mentioned against discharging firearms in public places. And when we looked the laws up, one of them was a Virginia law that said it's illegal to discharge a firearm at another person in a public place with intent to kill. And another one of these discharge laws was a law that disarmed slaves, having nothing to do with discharge. I don't know where they got their history degrees, but and then you got D.C. arguing, well, registration has a long history in the English experience, and they quoted a 1660 law where Charles II said that gun makers had to report gun purchasers, and then 2 years later he decreed a law that his lord's lieutenants could go search houses at will and seize guns from disloyal people. So here you have, this is perfect for D.C. I mean, to rely on a law that was decreed by a monarch to basically repress the population, the kind of law that Heller said was the sort of law that the Second Amendment was designed to prevent, and that's what they want to rely on. And then we get to so-called assault weapons. They said they're not in common use because we say so. We have evidence that there's been at least 2 million AR-15s manufactured for civilian use. And that's not good enough to be in common use. They say, well, we don't know what the percentage use in the population is. Well, guess what? We don't have those records because Congress made it illegal to have a registration system of firearms. So, we're all over the place with this, but it's just a continuation of the same kind of struggle between good and evil and rights and control. We're fighting for the constitutional right. They're fighting against that right, and they lose a case in court. They'll try to make the law worse.
Absolutely, and you bring up the historical references that they mentioned. You said the 1660 law that Charles I passed in England. If I'm not mistaken, Steve, 1660 was right at the tail end of the English Civil War. The idea that anything that Charles I would have done at that point in time would necessarily have any sort of bearing on the world that we occupy in 2010. I mean, this was a monarch,
right.
Dealing with a very fragile political situation, wanting to disarm his political enemies. Are they just grasping at straws here, Steve?
I mean, those were the days when if the king was a Catholic, he would disarm Protestants. If he was a Protestant, he would disarm Catholics.
Yeah.
Charles was a Catholic. He was trying to disarm Protestants, and the reaction against that led to the Glorious Revolution, it's called, of 1689, and the Declaration of Rights of that period, which referred and guaranteed the right of Protestants to have arms for the defense and security.
So in other words, they'll cite the egregious overreach even of a monarch, but they won't acknowledge the act of Parliament that rescinded that act 20 years later. Right.
They think that the oppressions that led to the need for the Bill of Rights are what the Bill of Rights allowed. And I mean, the Second Amendment was designed so that the government couldn't require registration of guns so that they could confiscate guns. That was the whole purpose of registration. And so it's a total flip-flop. What if you said that about the Fourth Amendment? The 1662 law allowing the Lord's lieutenants to basically break into people's houses and to search for guns and for seditious printed matter. I mean, that's what the First Amendment and the Fourth Amendment, they were designed to protect against that.
Mm-hmm.
If you read D.C.'s logic, you would think that means that's what the Bill of Rights allows. Another interesting thing in the brief, they admitted that magazines that hold more than 10 rounds are in common use, but they say, well, you might never need it for self-defense. We said that, well, not having to reload to put in another magazine in a very tense situation might help a gun owner defend himself.
Mm-hmm.
And their argument is, well, what's the likelihood of that happening? But if you go back to Heller, what did they do with the trigger lock requirement? They threw it out. The Supreme Court did not require a gun owner to show that, well, it's likely that I'll need to defend myself. They made it possible that you could defend yourself if you needed to, that there's no likelihood of need that's required to be shown here. So what we've done is shown them that we have American people use these guns and they use these magazines very commonly, and D.C. wants to be able to say that, well, a committee said otherwise, and so that's what the truth is.
Wow. Well, Steve, again, I'm glad you could come on the program, give us the very latest on this case, and let us know when there are updates. We'll be happy to have you back on.
Well, we've got an oral argument set for November the 15th.
Okay. All right. Well, we will be sure to talk to you then.
Okay.
Steve, thank you so much, sir. Have a great evening.
Yeah, you too, Cam. Thank you. Bye-bye.
Second Amendment attorney and scholar Steve Hallbrook joining us tonight for the Civil Rights Roundup.